So in today's conversation, we're going to be talking about a number of issues that are increasingly relevant as a result of the financial destruction caused by the COVID-19 pandemic and the associated shutdowns. We're going to start off talking about credit reporting and credit repair and things people can do to try and recover their credit. We're going to talk about debt collection and the Fair Debt Collection Practices Act, protections people have from abusive debt collection. I'm going to talk about exemptions, the laws that protect certain property from debt collectors. Talk a little bit about bankruptcy and how bankruptcy could be a useful tool for some people to restore their finances. And finally, a little bit about foreclosure and loan modification for people who have fallen behind on their mortgages. Throughout today's presentation, if anybody has any questions, feel free to jump right in. You can type them in the chat box, or you can unmute yourself and just let me know. I want this to be an interactive presentation, so I don't just have to talk for an hour straight while you all listen. So moving on to credit reporting and credit repair. Credit reporting has become an increasingly powerful tool used by all sorts of companies that has all sorts of effects on people's day-to-day lives. It's not just about getting a higher interest rate when you get a credit card or buy a car, buy a house. Having bad credit can increase your rent. It can give you higher insurance rates. It can make it harder to find a job. And unfortunately, about 20% of consumers have errors in their credit reports. So we're going to talk about how people can correct those errors. There are certain protections that were put in place about this time last year as a result of the COVID-19 pandemic and the CARES Act. So before we go into some of the specifics of credit repair, let's talk about those protections so people can hopefully take advantage of them. Anybody who fell behind on their mortgage and is taking advantage of the CARES Act mortgage forbearance should not be getting late payment reported on their credit as long as they were current prior to the pandemic starting. People with student loans should have seen, at least people with federal student loans, should have seen their payments be put into forbearance automatically during this process, and as a result, there should be no late student loan payments from federal student loans on credit reports. And then the Consumer Financial Protection Board published some guidance that said that any what they call a furnisher, which is somebody who provides information to the credit reporting company. It's usually a creditor, somebody who is owed money. Any furnisher who's making a COVID-related accommodation, so for instance, deferring payments on a car, credit card, any kind of accommodation like that should not change the reporting status of borrowers as long as they're meeting the requirements of those accommodations. So in most cases, that would just be contacting that furnisher, that creditor, and notifying them that they were affected by the COVID pandemic. And in that case, the credit reporting should not change, except if the affected person was having their account current, in which case, of course, you'd want to improve the credit by saying that account current. But your credit shouldn't be going down because you're taking advantage of one of those COVID accommodations. So getting back to general credit reporting law, the federal credit reporting statutes refer to consumer reporting agencies. These are the agencies that aggregate, that collect all of the credit reporting data and then share those credit reports with interested parties, usually lenders. There are three major consumer reporting agencies: Equifax, Experience, and TransUnion. Those are the ones people are familiar with. But consumer reporting isn't just about those three big credit reports. There are also employment-specific credit reports, landlord-tenant style credit reports, saying whether or not somebody's left in the middle of a lease, for instance. Check and bank-related credit reports. One of the big ones is Check Systems, that has reports of whether you had a bank account closed in an unsatisfactory status, meaning you owed a balance to the bank when the account was closed. There are insurance-related credit reports that insurance companies use to track claims, medical credit reports. There are subprime-specific credit reports that subprime lenders and payday lenders use to keep track of people who don't show up in regular credit reports, utilities, even gaming. So in all of these cases, these consumer reporting agencies are subject to the Fair Credit Reporting Act. It's a federal law that gives certain rights to consumers with regards to their credit. So that includes the right to review your report. You have a chance to see what's being reported about you. You have a right to know what data was used in the case of an adverse action. So if you apply for a credit card and they decline you because of your credit report, you have the right to know why you were declined. Was it because you have too many delinquent payments, not enough credit history? And you also have a right to dispute inaccurate data in those credit reports. However, this is a really important key, especially when we talk later about credit repair organizations. You do not have the right to remove accurate derogatory data from your credit report unless it's stale. And again, I'll talk a little bit more about stale data in a little bit, but if the information in the credit report is accurate and you were in fact behind, you don't have an automatic right to dispute that and remove that from your credit report. The Fair Credit Reporting Act gives every consumer a right to receive one free report from each one of these consumer reporting agencies every year. And through April of next year, consumers can get one free report from the major credit reporting agencies. So again, that's Equifax, Experian, and TransUnion every week instead of just once a year. And you can get those reports through annualcreditreport.com. So every year, at least, and these days, much more often, everyone should be reviewing their credit reports at annualcreditreport.com and making sure that the information included is accurate. So like I said, you can't remove accurate information from your credit report unless it's stale. And stale usually means it's 7 years old. And they go off of when the first derogatory report came for that trade line. So the first time you were 60 days late on a credit card, or the first time a credit card was charged off, or the first time you missed a car payment, that would be the first derogatory report. And derogatory information related to that trade line can only remain on the credit report for 7 years. In theory, your credit reporting agency, your consumer reporting agency is tracking that and getting rid of it, but in reality, they're not. So you'll find a lot of stale information on credit reports, and it's the obligation of the consumer that is the subject of the report to get that stuff off if it's more than 7 years. One exception to that 7-year limit is Chapter 7 bankruptcy. Chapter 7 bankruptcy can be reported on a credit report for 10 years after the filing of that Chapter 7. So if there's incorrect information on a credit report, what can you do about it? Well, you need to file a dispute. Disputes can be sent electronically or by mail. And the easy way for a lot of people is to just go through their credit report. And for certain credit reports, there's an automatic kind of check the box dispute. And you just check the box, you say this is disputed, and you put a brief sentence or two about why it's disputed. In the case of a serious error in the credit report, you may want to go further. You may want to send a dispute by mail, certified mail, making a copy of it. That builds a better record if you end up in litigation about this credit reporting dispute. But there's no requirement in the law that you send a certified letter disputing information on your credit report. All you really have to do is just notify the credit reporting or the consumer reporting agency that the information is disputed. You do have to provide sufficient information to the furnisher to investigate. So who's the furnisher? The furnisher is the company that is providing the information to the consumer reporting agency. If you're complaining about your Target credit card, that's the bank that handles Target credit cards. If you're complaining about your mortgage, it's your mortgage servicer. They're the ones who ultimately investigate the credit report and determine whether that information is accurate or inaccurate, and then they report that back to the consumer reporting agency. So there is a duty to reinvestigate that is placed on this furnisher when the consumer reports a dispute. They will determine whether it's accurate or inaccurate, and they will report that back to the consumer reporting agency, who then reflects that information on the credit report. So that leads to credit repair. Credit repair is always a popular business because people want to remove derogatory information from their credit reports. Unfortunately, as I said earlier, there is no right to remove accurate derogatory data unless it's stale, unless it's 7 years old. Disputing accurate information will not improve your credit report or credit score for a very long time. You may get a short benefit because while a dispute is active, the consumer reporting agency has to report that there's a dispute about this information. But once that dispute's resolved, once the furnisher comes back and says, yes, I've verified that this person was in fact delinquent, or whatever the derogatory information is, that credit report goes back to just the way it was before. So just sending a dispute that doesn't have any basis isn't going to do you any good. As a result of this proliferation of people trying to help, or companies trying to help people with their credit, Congress passed the Credit Repair Organizations Act, and this is trying to protect people from unscrupulous credit repair organizations. It ensures that prospective buyers of these services are provided with the information necessary to make an informed decision regarding the purchase of such services. In other words, you're going to get what you're paying for. It also protects the public from unfair or deceptive advertising and business practices by credit repair organizations, and prohibits those credit repair organizations from using misleading or false statements with regards to credit or creditworthiness, and also prohibits those credit repair organizations from counseling or advising consumers to make such statements. So what does that mean? That means that not only can these organizations not, for instance, file a bunch of disputes on your behalf with no basis, saying, for instance, we believe this account was paid in full when they know that it was not. They also cannot counsel consumers to do that, to make frivolous disputes. This Credit Repair Organizations Act also prohibits these credit repair organizations from charging in advance. And that gets back to the idea that if you really understand what you're getting from a credit repair organization, which is just assistance doing something you could do all by yourself, you may not really want to pay for it. And you certainly wouldn't want to pay in advance, because then you have trouble getting your money back when you realize you were ripped off. So are there any questions about credit repair before we move on? Or credit, not just credit repair, but credit reporting? If not, we will move on to debt collection. So before we go too far into debt collection, just a couple of quick definitions. A debtor is one who owes a debt. And this ends up being really confusing to a lot of people, because they think that the person who the debt is owed to is the debtor. But in fact, the debtor is the one who owes the debt. The creditor is the one to whom a debt is owed. Exemptions, like I mentioned earlier, legal protections which prevent creditors from taking a specific type of asset from a debtor to satisfy a debt. And we'll go through a lot of the common exemptions in Nevada in just a second. And then arrears. Arrears are past due payments owed on a lease or a secured debt. So if you're behind on your rent, you're behind in your car payments or your mortgage, you have arrears. And we'll talk about that when we're talking about what you can do when you are in arrears. So debt collectors have to follow certain rules when collecting debts, and one of the biggest is the Federal Fair Debt Collection Practices Act. This regulates third-party debt collectors, and that just means that this law protects consumers from people whose only job is to collect debt. If you get a credit card from Wells Fargo and you don't pay it and Wells Fargo calls you, Wells Fargo is not subject to this Fair Debt Collection Practices Act. If Wells Fargo hires Bob's debt collection and Bob gets you on the phone and starts harassing you about paying Wells Fargo, that third-party debt collector is subject to the Fair Debt Collection Practices Act. In Nevada, there's a couple other creditors that, even though they're not third parties, they are the original creditor, the person to whom the debt was originally owed, they're still subject to these protections. And specifically, those are high interest lenders, payday lenders, title lenders, and hospitals. When they're collecting their own debts, they're still subject to these protections. These protections include that you cannot be called by a debt collector at an inconvenient time, and that's specifically defined as anytime after 9 p.m. and before 8 a.m. in your time zone, not in the debt collector's time zone. Debt collectors cannot communicate with third parties about the debt, with a really limited exception. They can call your mother and say, hey, do you know where John is? Any other information or any other request in that phone call is illegal. With the exception of inquiring about the location or contact information, they can't say that they're calling to collect your debt. They can't try to harass that person to collect your debt. No communication with third parties unless they're just trying to locate you. Debt collectors cannot make any threat of legal action they're not legally allowed to take. They can't say, we're going to throw you in jail. We're going to put a warrant out for your arrest if you don't pay this debt. They cannot use any unfair or unconscionable means to collect a debt, which includes, but is not limited to, swearing at debtors, threatening to harm a person or property. The word used in the Fair Debt Collection Practices Act is abuse. They cannot do anything abusive in an attempt to collect the debt. Even more powerfully, the Fair Debt Collection Practices Act prohibits continued communication after a creditor receives a request to stop, or what we call a cease communication letter. If you're getting a call from a debt collector, you're not able to pay them, you don't want to pay them, you don't want to deal with it, you're sick of them, just send them a letter. Say, don't contact me anymore, and they cannot contact you anymore. Now, you don't have to send a letter, just like with the credit reporting disputes. Just simply saying on the phone, don't call me anymore, triggers this protection. The problem there is one of evidence. You have to be able to prove to the court that you told them to stop. And that's where having a letter is great, because you have your proof. The Fair Debt Collection Practices Act has a couple other provisions. It requires a specific disclaimer before any communication and attempt to collect the debt. You probably heard it. This call is an attempt to collect the debt, and any information obtained will be used for that purpose. There's also disclaimers that have to be on written communications. The first communication has to include the debt collector has to say, you have the right to dispute this debt, to verify this debt, as long as you get back to us within 30 days. So if you get communications about a debt you do not owe, you can send a request back and say, I don't recognize this, I dispute this debt, I need verification. While that verification is being obtained, while they track down the information that proves you owe the debt and send it to you, that debt collection has to stop. Now, while the communication must stop once the debt collector gets that request to stop communication, that doesn't stop the debt from being transferred to another debt collector who can then proceed to collect the debt, from just going back to the original creditor who can attempt to collect the debt. And most importantly, it does not stop that original creditor or anyone that bought the debt from the original creditor from filing a lawsuit to collect the debt. So for some people, it's enough to just send a letter to the debt collectors and say, leave me alone. But for a lot of people, unfortunately, that's not going to be enough, because they will end up receiving a lawsuit to collect the debt. So all lawsuits start with a summons and complaint. A summons is just a piece of paper that says, hey, you've been sued, here's how you respond, and here's your deadline to respond. The complaint sets out the relevant facts and legal theories explaining why the court should award damages. The defendant, which is usually a debtor in a debt collection lawsuit, has 20 days to respond to that lawsuit. And they usually respond by filing an answer. That's the legal document that they call the answer is a document filed with the court which explains whether the allegations are true or false, one by one. I'm a resident of Clark County, Nevada. I admit that. I owe this debt. I deny it. And then it also sets out defenses to that debt. If the defendant doesn't answer, doesn't file a response, the plaintiff wins a default judgment, which means they win whether they were really owed the debt or not. Common defenses to a debt collection lawsuit are that the wrong party was sued. You don't even have to have a common name to be pursued for someone else's debt. It's incredibly common. A debt was partially or fully repaid. Unfortunately, record keeping is not very good when it comes to debt collection, and so you may have previously settled the debt, you may have paid, they may not have calculated the amount of debt correctly. That's another good defense. And then a big one is the statute of limitations is run. Like just about every other law, there's a statute of limitations to enforce a contract, and in Nevada, that's usually a 6-year statute of limitations. It may be different depending on the governing law of the contract. So when you get a credit card, that's comes with a cardholder agreement. That's your contract that says you agree to repay, and it may have any number of states' law. Delaware is interesting because a lot of credit cards come from Delaware. Delaware only has a 3-year statute of limitations. But if the debt being collected is past the statute of limitations, then that's a perfect defense to the debt collection lawsuit, and the debt collector is going to lose. One thing to bear in mind about the statute of limitations is it is triggered, or it's the time starts running not only when you default, but also if you make a payment. So if you don't make a payment for 5 years on a debt, some debt collector calls you up and guilts you into making one payment, that restarts that 6-year statute of limitations. So it's best to not make payments once a debt's getting close to that statute of limitations in a lot of cases. Assuming that the debt collector wins in court, either because the defendant didn't respond at all and the plaintiff got a default judgment, or because the judge was convinced that the debt was actually owed, that debt collector gets a judgment, a court judgment. And there's a few ways they can collect the judgment. They can collect the judgment through a wage garnishment, going to the defendant's employer and saying, give me a portion of every paycheck. They can collect through a bank levy, going to the bank and saying, hey, give me all the money out of their bank account. Or they can seize assets, which is much less common, but is a legal way to collect a debt. And in Nevada, these judgments are good for 6 years from the date they're entered by the court. However, they can also be renewed indefinitely. So when you get close to the end of the 6-year time period, that doesn't mean that you're off the hook. All that creditor has to do is file a document with the court saying, this debt's still outstanding, it hasn't been paid, and they'll renew that judgment and they can keep collecting on it. So that leads to exemptions. Just because a bank gets a bank levy that says, give me all the money in the bank account, that doesn't mean that creditor gets all the money in the bank account. Just because they say, I want to seize a car, a house, what have you, doesn't mean they automatically get it, because Nevada, like every other state, has exemption laws that protect assets. Here's a quick rundown of the common exemptions. Primary residence, good up to $605,000 in equity. It's triggered by a homestead exemption, so you do need to file a homestead exemption to take advantage of this, or file a homestead declaration to take advantage of this protection. But you can file that homestead declaration the day before a sale, so there's not always a huge hurry. Still, always recommended anytime somebody buys a house, record their homestead declaration. You do have to be living in the property for it to be your homestead. Cars are protected up to $15,000 in equity. So if you have a $20,000 car, but you owe $5,000 against it, you can still protect that car. Household furnishings, so clothes, furniture, etc., $12,000 in protection. Art, jewelry, instruments, keepsakes, up to $5,000. Pensions, including IRAs, 401ks, any kind of retirement accounts protected up to $1 million, and life insurance is protected in any amount. Tools of the trade, things people use to do their jobs, are protected up to $10,000. Much more importantly, for a lot of the people I and probably you deal with, public benefits are all totally protected from creditors. That includes food stamps, welfare, unemployment. It's all protected. Unspent Social Security income is protected from garnishment or from bank levy. 75% of paid wages, or 82% of the wage, if the weekly wage is $770 or less, is protected. And also up to 50 times the minimum wage is protected. So people that get really small paychecks don't have to worry about getting garnished. Restitution received as a victim of a crime is protected from creditors. And then finally, there is a wildcard exemption. Wildcard exemption can be applied to any personal property, so you can apply it to real property, but that is a very good way of protecting things that don't fit into any other category. And this is particularly relevant right now because there's another stimulus check coming out, and unlike the last stimulus check, but like the original one that came with the CARES Act last April, this stimulus check is not specifically protected from creditors. So a lot of banks, or a lot of people with judgments that creditors are going to be waiting for those stimulus checks to get direct deposited and then send out their bank levies, because they say, here is our chance to finally get our money back. This wildcard exemption is what people can use to protect that stimulus, because it applies to everything, any sort of deposit. The best news is that the most common exemption that gets applied, which is that wage exemption to wage garnishment, is usually calculated by the employer, and the employee doesn't need to take any action to protect themselves in that case, unless the calculation was done incorrectly. That's usually a little more than most people can handle. Anyone's welcome to come ask me at Legal Aid to double check their calculations. There's also the Civil Law Self-Help Center at the Regional Justice Center. And right now it's just operating by telephonically, but I think we're going to be opening it up again to the public pretty soon. Also happy to help review these garnishments to make sure they're taking out the correct amount. But in general, the employers are doing it, and the constables are doing a decent job making sure that that information, or that the amount taken from paychecks is the correct amount. There's also a couple of automatic protections, one from Nevada Revised Statutes Chapter 21 that automatically protects $400 or the entire amount in a bank account, whichever is less, from a bank levy. So people who don't have a lot of money in their bank accounts don't have to worry as much that the whatever little money they have is going to get taken. 1 month of federal benefits, for instance, Social Security, VA benefits, are automatically exempt, which means that the bank won't even send that money to the constable if that's not commingled. And commingling is a huge issue in this case. Commingling means that you're not just putting one source of income into the bank account. If you just get your Social Security every month and it goes automatically into your bank account and nothing else ever gets deposited, it's really obvious to the bank what that 1 month of Social Security benefits is going to be, and really easy for them to say, sorry, there's no money available for a bank levy. If you're also getting money from unemployment on your debit card, taking it off the debit card, putting it in your bank account, if you are getting rent from somebody that's moved into your house, getting a loan from somebody, any other money that's getting deposited into the bank account is going to mess up the calculations to protect that automatic protection for Social Security. And that puts it into this next category. Any other exemption, all the ones I just talked about, have to be affirmatively enforced by the judgment debtor. It's not automatic. It's up to the person who's had their property taken to go to the court and say, hey, that's mine, I get it back, it can't be taken. Usually the way they do that is filing a claim of exemption from execution with the court that issued the judgment. It's a fairly simple form. We have a check the box form at our Civil Law Self-Help Center and the Civil Law Self-Help Center website that says, for instance, the money in my bank account came from Social Security, it's protected. Or the money in my bank account is protected by this wild card exemption. Whichever exemption you would claim, you just check the box. You then serve it on the judgment creditor, the constable, and file it with the court. And then the court can set a hearing if the judgment creditor objects to it. So we have more information about those claims of exemption at the Civil Law Self-Help Center website. Links here on the screen. It's Civil Law Self-Help Center, all one word, .org. Now, for some people, as you can probably imagine, they are what we call collection or judgment proof. That means that they don't have any income or assets that are not protected. So again, somebody who only gets Social Security income, doesn't have any other source of income, may have as a car worth less than about $15,000, may have a house that's worth less than $605,000. There is nothing that a creditor can take from them because everything they own falls into those exemptions. So we call that person collection proof or judgment proof. In a sense, they don't need to worry about these judgments against them because there's nothing the creditor can take. However, like I mentioned earlier, in some cases, it's up to this judgment debtor, the person who's been sued, who has the judgment against them, to affirmatively go out and protect their assets, to file that claim of exemption. And that's something that we can help with at Legal Aid, but if they don't, if there is a bank levy and the money comes out, even if it did come from Social Security, even if it is otherwise protected, that judgment creditor is going to take it. Now that's kind of debt collection in a nutshell. Any questions about debt collection before I move on to the next topic? Again, feel free to just type questions at any point. You don't have to wait for me to ask. If you have any questions, type them in the chat box or unmute yourself. Just let me know. Okay, how long do they have to renew the 6-year judgment after the 6 years has passed? Is there a time limit for that? Great question. Actually, the 6 years is the time limit. They have to renew it within, I want to say it's 60 days before, but it's a fairly short amount of time before the 6 years is up. If the 6 years is up and they didn't renew the judgment, it's invalid. And of course, you can't do it too early, but there's a little time window for judgment creditor, maybe 6 months, but there's a time window for judgment creditors to file those renewals. And if they miss the 6-year window for some reason, they're out of luck. Any other questions? All right. So now on to bankruptcy. Unfortunately, there are people who are not collection or judgment proof. Again, that means that they have, it's usually income, sometimes it's assets, that's available to their creditors, and they're not going to be able to deal with their debt any other way. Obviously, if somebody has just one credit card, they're going to be able to get onto a payment plan. In some cases, if you wait a while, the amount that the credit card company is asking for is going to go down because they're thinking they may never get their money. And so they could settle with the one credit card, or you give up a car and luckily it's worth enough that it pays off the debt you have against it. You're going to be okay. But unfortunately for a lot of people, they're not going to be okay. And that's where bankruptcy comes in. So bankruptcy is a federal court proceeding whereby a debtor can discharge or adjust their debts. And discharge just means that those debts are no longer legally enforceable. One thing that people don't always understand about bankruptcy is that it isn't just about discharging debts. It's sometimes about adjusting debts. And that's usually the realm of Chapter 13 bankruptcy that we'll talk about in just a little bit. Most debts are discharged so long as the debtor is acting in good faith. And that's another really important thing to bear in mind with bankruptcy, is that bankruptcy is a wonderful tool for getting rid of debt you cannot afford to pay, but it is a horrible place to be if you think you're going to get away with lying, with acting in bad faith in any way. Because believe me, in bankruptcy court, they've seen it all, they've caught it all, they will catch whatever people are trying to pull, and the penalties can be really, really bad. Criminal penalties, they will find and take whatever you have, and they will use it to pay your debt. So you got to be acting in good faith if you're going to file a bankruptcy. And 99% of the time, that's not a problem. Bear in mind also, certain debts are not dischargeable. Bankruptcy doesn't work for everything. It doesn't work for debts incurred by fraud, which gets back to that good faith requirement. If you're going to lie to people, steal their money, and then when they come to try to get their money back, say, oops, I can't pay it, bankruptcy is not going to help. Alimony and child support, not dischargeable in bankruptcy. Most taxes, not dischargeable in bankruptcy. And finally, unfortunately, student loans are currently essentially not dischargeable in bankruptcy. There is a way for people to argue that their student loan should be discharged. It's called an undue hardship standard, but it's much harder than it sounds. Hopefully we'll see some changes in that area, but right now student loans are not a good, bankruptcy is not a good way of dealing with student loans. So like I said earlier, there's two kinds of consumer bankruptcy. There's actually several kinds of bankruptcy, but in terms of the kind of bankruptcy people tend to file when they're just consumers, Chapter 7, Chapter 13. Chapter 7 is the traditional liquidation bankruptcy. If you have assets that can be used to pay your debt, they'll take them from you. Otherwise, your debts just go away. Chapter 13 is that adjustment or repayment bankruptcy where you may end up paying all or part of your debts. So there are a couple of differences between these two chapters of bankruptcy. Chapter 7 is a pretty quick process. It only lasts about 4 to 6 months from the day you file until you get that discharge order and you are all done. Chapter 13 bankruptcy is a much lengthier process. It's a 3 to 5 year repayment plan in most cases. CARES Act has been extending some past the 5 years, and if you manage to pay off all your debt in less than 3 years, you can be outside of that window, but almost all cases take between 3 to 5 years. There is an income limit in Chapter 7. I'll give a little more information about that, but it's typically the median income, the average income. If you make less than that, you can do Chapter 7, get rid of your debt. If you make more, you may not be able to. Chapter 13 does not have any income limits. If you have arrears, if you're behind, and I talked about arrears at the very beginning of this debt section. So arrears are when you're behind on a payment, like you're behind on your car, you're behind on your mortgage payments, you're behind on your rent. In Chapter 7, you're likely to lose it, or in the case of rent, you're likely to get evicted. The Chapter 7 is not a good way of dealing with the fact that you have fallen a little bit behind and you want to catch up. In Chapter 13, on the other hand, you have a chance to catch up on these arrears. You have up to 5 years if you want to catch up on mortgage payments, for instance, to pay off a car at a much better interest rate. And then Chapter 13 also has a mortgage modification mediation program. And this is similar to the Nevada state mediation program that I'll talk about in a little bit, but it's a way for a homeowner to work with the mortgage company to try and find a solution, some kind of loan modification or other solution to the problem other than foreclosure. So Chapter 13 is one of the best options for people who have fallen behind on their mortgage payments. And then the last big difference between the two chapters is non-exempt assets. And we talked about the exemptions in terms of Nevada law before, what protects debtors after they've been sued in a debt collection lawsuit. Almost all of those exemptions are identical in bankruptcy. If you have 3 cars, you have a 5th wheel, you have a second home, you have a bunch of money in a savings account. In Chapter 7, if it doesn't fit into one of those categories we talked about earlier, you're probably going to lose it. They will take it, they'll use that money to pay whatever portion of your debt it covers, and then the rest of it will be discharged. Chapter 13, on the other hand, is not a liquidation bankruptcy. They don't take stuff from you. Now, there's still a requirement in Chapter 13 that people don't end up any worse off. Creditors, the people that the debtor, the person who's filing the bankruptcy owes, shouldn't be any worse off than they would be in Chapter 7. But instead of, for instance, having to sell that car or losing that savings account, as long as they get the creditors get the same amount of money by the end of that 5-year plan with just monthly payments you have to pay anyway, then you can keep your assets in Chapter 13. You cannot in Chapter 7. And one of the best things about working for Legal Aid Center is that I can get people Chapter 7 bankruptcies for free. I can get attorneys to volunteer and to do these bankruptcies pro bono, which means that if people cannot afford to pay their bankruptcy attorney, we can still get them a bankruptcy. I'll talk a little bit about the requirements for that later on. So like I said earlier, in terms of Chapter 7, there is an income limit. You can't make too much money and file Chapter 7. So I said that the main guideline is the median income. And here's the median income numbers for Nevada right now, about $53,000 for one-person household, up to about $83,000 a year for a 4-person household. So the vast majority of people that we deal with are going to fit into this Chapter 7 box. The other requirement, I guess not on the slide, sorry, but it is that you have not filed Chapter 7 before in the last 8 years. You can only file Chapter 7 once every 8 years. For what it's worth, people that are just a little bit over these median income guidelines may also be able to file Chapter 7 if they can pass what we call the means test. And the means test is this complicated form that is designed to decide whether or not somebody can afford to repay a meaningful amount of their debt over a 5-year period. So it's pretty rare to qualify for Chapter 7 if you're above median income, but sometimes it happens, usually because you have a really high mortgage payment or really high child support or alimony obligations. All right, so like I said, legal aid can get pro bono attorneys for Chapter 7 bankruptcies. We can help people file bankruptcy without having to pay an attorney. However, you have to meet our income guidelines. And these are our income guidelines, not just for bankruptcy, but for most of the stuff that we do. Again, it's based on the number of people in the household. So for people that make less than $27,390 for a single person household per year, or about $2,300 a month for a single person household, going all the way up to about $39,000 for a 4-person household, or $3,263 a month. And then all the way up to about $50,000 a year if you got a whole lot of people in your household. And so if you meet that income guideline and you have less than $5,000 in net assets, excluding a house or 1 vehicle, we should be able to find you a pro bono bankruptcy attorney. So please refer anybody that you think needs help, or anybody who just has questions about whether bankruptcy would be a good or bad decision for them, to us at Legal Aid. I can answer that question for anyone. I can get an attorney to volunteer for the case if the person you're referring meets these income guidelines. Any questions about bankruptcy before we move on to the last topic, foreclosure and loan modification? Uh-oh, okay. So here's the quick timeline of a foreclosure. Starts when somebody falls behind on their mortgage payments. Once someone is 3 months behind on their mortgage payments, the servicer is the company that accepts the mortgage payments on behalf of the company that's actually, or entity, it's usually a trust, that's entitled to the money. the servicer can declare the loan in default once the 3 missed payments have happened. Doesn't always happen immediately. Sometimes it doesn't happen for years after the 3 payments are missed, but the servicer cannot declare the loan in default until at least 3 payments have been missed. At some point, after the loan has been declared in default, sometimes immediately, again, sometimes years later, the servicer records a formal notice of default, and that starts the non-judicial foreclosure process in Nevada. I should also point out that there's a judicial foreclosure, a process that goes through the courts. It has much longer timelines and isn't all that common, so I'm not going to worry too much about it right now. But in this non-judicial foreclosure context, the servicer has to record this notice of default with the county recorder to start the foreclosure process. They also have to post a notice to the door, and they have to send at least 3 certified copies to the homeowner. This is the formal event that starts this foreclosure process. Once that notice of default has been entered, there is a period for the borrower to get back out of default, to catch up. That has to be at least 90 days. This notice of default also triggers the state of Nevada foreclosure mediation program. Within 30 days after that notice of default, the homeowner can file a petition with the court and say, I want to participate in that foreclosure mediation. If the foreclosure mediation does not result in an agreement where the homeowner can keep their home, or if the homeowner does not go into the mediation program, Home Means Nevada, which is a company that the legislature has created to administer this program, will issue a certificate that says the foreclosure can go forward. And once that certificate's been issued and 90 days have passed since that notice of default has been recorded, the servicer can issue a notice of trustee sale. And that's the document that specifically says what day this foreclosure is going to happen. When is this house going to be sold to somebody else? That sale date has to be at least 21 days after the date that the notice is recorded. Again, this notice, just like the notice of default, has to be taped to the door, has to be mailed, certified copies, has to be recorded with the county recorder, so there's a permanent record. If the balance that's owed is not paid within that 21-day period, the sale occurs. And at that point, that's like the point of no return for most of these sales. Once that happens, there is no way for that homeowner to be able to keep that home because it now belongs to somebody else. And sometime, usually within 2 or 3 weeks after that, the trustee's deed upon sale is recorded that actually transfers ownership from the former homeowner to the new homeowner. And the reason I give this timeline is so that you can figure out where somebody is in the timeline when they come to you for help. If they are after that last trustee sale or trustee's deed, it's probably too late to help them. You can always send them over. I can see what I can do, but it's probably too late. If they are, basically the higher they are on this list, the earlier they are in the process, the more options we have to help them. If they have passed that 30-day period after the notice of default's entered, it's too late for them to do the foreclosure mediation program, but not too late for them to take advantage of some other options to try and save their home. And I talked about these timelines before. The borrower must be 90 days in default before a notice of default can be recorded. Notice of trustee sale cannot be issued until 90 days after the notice of default was recorded, and the trustee sale cannot occur less than 21 days after the notice of trustee sale is issued. So whenever somebody comes to you in this process, unless they're past the last point and their home's actually already been sold to somebody else, they have resources that they can use to help. One resource that's new, or fairly new, and also is from Home Means Nevada, the same company that handles the foreclosure mediation program, is a web portal called Nevada Homeowner Connect. And I'd strongly encourage people with mortgage issues to take advantage of this resource because it's free and it's a great way to work with mortgage servicers. So it's a web-based portal for homeowners to communicate with their lender/servicer to resolve their concerns. And it isn't just about missed payments, although it can be. It can be used to request or to discuss COVID-related forbearance, loss mitigation requests. And loss mitigation is a whole realm of things that the mortgage servicer can do in response to default. And any other servicing dispute. Has questions about their escrow payments or something on their mortgage statement, they can go through this Nevada Homeowner Connect. I have the website here. on the slide. It's the homeownerconnect.org/Nevada. Again, it's a free service, and it also can help connect people with HUD housing counselors. And of course, Legal Aid Center of Southern Nevada. I am always happy to help homeowners with foreclosure issues. They can, or any other mortgage servicing issue. Just reach out to us and we will try our best to help. So like I said, loss mitigation can be a number of things. It can be a loan modification, agreement to permanently change the terms of a mortgage. Unfortunately, I think we're going to be looking at some sales. Now, it used to be in 2010, 2011, when people had to sell their home because they couldn't keep it anymore, it would be a short sale. They owed much more than their home was worth. We may find ourselves at that point again. I've never been able to accurately predict home prices, and I'm not going to try now. I don't think that's going to be as common now as it has been. I think a lot of people are going to be able to sell their homes in a traditional sale if they can't keep up with their mortgage payments, which is great news, because when there is a foreclosure, then that house is going to sell for a much lower amount than the homeowner could sell it on their own. When you're selling through a normal realtor or a regular transaction, there can be inspections. People can come in and look at the home. They're not worried that the home's going to get snatched up last minute. At a foreclosure sale, none of those are true. So if somebody is looking at a situation where they have a significant amount of equity in their home, they know they're not going to be able to go back to work at the job they used to do, or at least not anytime soon. They're not going to be able to maintain their mortgage payments. They can't refinance. They should strongly consider selling their home, getting that equity out. There's a really big timing issue, though, with that. We talked about it earlier when it comes to exemptions. The equity you have in your home is protected against your creditors. Once you sell your home, the equity is not necessarily protected. It gets a little complicated over the short term if you're going to buy another house, but in general, that may be money that's now available to all the other people that you owe. So that people will, in general, prefer to deal with their debt first and then sell their homes. And then the last option, a deed in lieu of foreclosure, transferring a home to a lender without going through foreclosure, only makes sense in that short sale context when they owe more than the house is worth. Otherwise, it's better to just sell the property, get whatever equity they can out, and use that to help fund their move if they can, or at least fund their lives for a while after they lose their home. A couple of tips to help people when they are trying to apply for loan modifications. Number one is start early. If somebody has been in a COVID-related forbearance because they lost their job last March and they haven't been able to get back to work, now is the time to work with their servicer if they can. If they're back working, not working the kind of job they used to have, their income's way down, start as early as they can working with their servicer to try and get a resolution to this. The longer they go without making mortgage payments, the harder it's going to be to fix the problem. Following up with the servicer often throughout the process. Unfortunately, the person on the other end of the phone when you're negotiating a loan modification probably just started their job, probably isn't very good at their job, and will soon be leaving their job. And so it's an obligation for the homeowner to work as much as they can with the servicers to try and maintain those communications, because the servicers are not going to be able to do it. Always make sure that any application is complete before you send it, because you may not get a second chance. To the extent you can, ask follow-up questions. So if you're working with a homeowner and they're talking about how somebody's been helping them out with the mortgage payments, you'll want to know, is that a permanent thing or a temporary thing when you're trying to guide them what they ought to be doing. Always want to calendar and clearly communicate deadlines. Like I said earlier, a lot of this stuff is deadline based, and if you miss a deadline and now the house has been sold, it is too late and you cannot go back and say, oops. Always make sure every homeowner has backup plans. I talked about that earlier. When it comes to, for a lot of people, unfortunately, I think selling the home is going to be the best thing they can do financially, and they want to know about that, and they should be thinking about that as soon as possible, because if their foreclosure sale is coming up in 21 days, that's the last big warning you get, you may not have enough time to market and sell your property. You may not know where you're going. You may not have saved up money to move, and so your home may be foreclosed on you just because you didn't move quickly enough and you were expecting your loan modification to come through. And then finally, you want to document everything. Like I said earlier, the loan servicers are not particularly good at their jobs, and so when you have documentation, you can use that against them if you run into a dispute. Finally, the state of Nevada has a foreclosure mediation program, which is a great option for people who would like to avoid foreclosure. It does require that timely petition to be filed. It has to be filed within 30 days of that notice of default. If you're 31 days out, you may be too late. The judge has a certain discretion, but it's pretty limited. And then there is a $275 fee you have to warn people about when it comes to the foreclosure mediation. At that point, there's a mediator appointed. It's a neutral third party. It's not somebody advocating on behalf of the homeowner or the servicer. They're really just more of a referee or facilitator. They don't make a final decision like an arbitrator does. And so whenever you're counseling somebody about foreclosure mediation, you got to let them know they're not going to a judge who's going to say, hey, this mortgage servicer is awful. They have to give you a loan modification. This is just somebody making sure they're following the rules. They do review lender documents. This is one reason why I do encourage people to take advantage of the foreclosure mediation program, because the mediator will make sure this servicer actually has the right to foreclose. I'm hoping that's not as big a problem as it was 10 years ago, but there are still loans out there with really shady paperwork, and it's nice to have a second set of eyes on them. And then finally, they issue a report after the mediation saying either an agreement's been reached, so hopefully this foreclosure will not go forward. Sometimes it's just that they'll give more time for a sale or for someone to move out, or no agreement's been reached. That's where that certificate gets issued and the foreclosure goes forward. So that's the presentation for today. Any final questions about anything I've covered or anything else that you're dying to know?
Hi, my name is, can you hear me okay?
Yeah.
Great. I have a question kind of going back towards the early part of the presentation about credit counseling slash, I forget the term that you used, but the kind of organization that will help submit disputes on behalf of a consumer to the credit bureaus and whatnot. You kind of framed it as in they can only do the kinds of submissions that you could do on your own behalf in that kind of a situation. And I'm wondering if you could go into a little bit more detail there, because I used to work at a credit card bank, and there were certain types of negotiated repayment schemes where I thought the bank would receive calls directly from some kind of credit repair agency, and they weren't actually fielding it specifically from the people themselves who had the credit card debt. Do you know if I'm thinking about maybe something different?
And there might be a little confusion about two sort of related areas. One is the credit repair organization. And that's a specifically defined term in the federal law, because they're talking about regulating people whose main mission is to repair the credit report. And that's different from a debt settlement organization, which is trying to help resolve the debts by working out a repayment plan or negotiate a settlement. So were you?
Gotcha. Okay. So we're saying when someone is when it's a credit repair company that is specifically trying to repair your credit report, independent of negotiations with the creditors themselves, those credit repair agencies are the ones that can only really do the submissions that you'd be able to do yourself.
Well, that's absolutely true, that a credit repair organization can only do a dispute that you could do yourself. And in fact, you're supposed to do your own disputes. You're not supposed to, I mean, you can hire an attorney to do it if you want, but yeah, there's very little value to a lot of people in a credit repair organization, because they're just sending a dispute. And a lot of times they're just sending blanket disputes. They're disputing everything, which again is illegal. But a debt settlement, the same rules generally apply, that you can negotiate your own debt settlements, your own debt repayment plans, and there's a huge variety of organizations that work in that area. You know, it's now called Money Management International. It's gone through a couple of name changes, but they are a nonprofit that just helps people work out debt repayment plans. And that's usually beneficial. And then there are shady fly-by-night places that make all kinds of outlandish promises they can't follow up on. Say, we will save you from all of this debt, just pay us $200 a month. And then 7 months later, the person gets a lawsuit because one of these creditors that they thought they were dealing with didn't get paid and sued. And in the meantime, 150 of that $200 went to fees. So there's no real benefit. So you got to be shopping very carefully if you're looking for somebody who's doing debt settlement. It's not that you can't get a benefit from it, but you got to make sure you're dealing with somebody who knows what they're doing. And in most cases, a lot of people can do that themselves. Just call up and ask what kind of deal you can make, and they'll give you the same deal they would give somebody who's arguing on your behalf.
Got it. Thanks for the clarification.
No problem. Any other questions? If not, thank you all for attending today's presentation. We'll try and send out a copy of this PowerPoint to everybody who attended. And like I said, we'll put this up on YouTube so you can refer anybody else who would find this information helpful to that YouTube